Good morning and welcome to the Clerk's annual meeting with the Bar. For the first time, we offered this meeting in person and via a WebEx. There were some technical difficulties at the beginning of the WebEx so that the telephone participants could not hear everything being said. In order to correct this, we are re-recording the first few minutes of the presentation, which will take us through a discussion of General Order 24-2018. The presentation that follows will be of the live recording. There are 3 general orders entered on October 31st, 2018, which will be discussed during this meeting. But I will begin with some statistics for the 12-month period ending September 30, 2018, which you may find interesting. Georgia Northern remains the 3rd busiest bankruptcy court in the country for that period of time, with 30,739 cases filed. The only 2 districts with more filings for the 12-month period were the Northern District of Illinois, which includes the Chicago metro area, with 40,245 cases, and Central District of California, which includes the Los Angeles metro area, with 37,343 filings. As you may recall, the highest filings for any calendar year in Georgia Northern was for 2010, where we had almost 55,000 cases. For the period ending September 30, we ranked 7th highest in the country in per capita filings per 1,000 residents at 4.45 filings. And for pro se filings, we were the 16th highest district in the country, with 9.9% of all filings coming from pro se litigants. Since we last met in 2017, it was a busy year for the court. We said goodbye to 2 of our judges, former Chief Judge Ray Mullins and Judge Mary Grace Deal, although Judge Deal is on recalled service by the 11th Circuit Court of Appeals and is handling mediation matters for the district. We also welcomed our 2 newest judges to the bench, Judge Jeffrey Cavender and Judge Sage Sigler. In the last 12 months, the clerk's office lost several key employees to well-deserved retirements, and we expect 1 or 2 more in the next several months. But because of good budget years, we are able to fill all vacancies with the court. We have people moving into new positions and doing some reorganization of the Atlanta senior management. Just a reminder that most of the federal government is under a continuing resolution, which runs through December 7, 2018. In the event that there is no budget or another CR is not put into place, the courts will continue to operate, even in what is generally termed as a, quote, government shutdown, unquote. Federal courts have non-appropriated funds at the national level that will sustain all court operations for approximately 3 weeks. So if you hear on December the 8th that the government is in a shutdown, please know that that does not include the U.S. Bankruptcy Court or the U.S. District Court or any federal court for that matter. So we will move to the 3 general orders entered by the court on October 31, 2018. As always, I will do my best to answer questions about the orders, but please keep in mind that I cannot make any interpretation on behalf of any judge, nor do I speak for them. I will simply refer to the actual language in the order and provide any detail that I can in my responses. The 3 general orders are General Order number 23-2018, payment of filing fees in installments to commence a bankruptcy case, General Order 24-2018, Voluntary Notice Procedures in Chapters 7, 11, 12, and 13, and General Order number 25-2018, Electronic Service of Pleadings. These orders were previously distributed through our Gov delivery system and have been posted to the website since the time that they were entered by Chief Judge Hagenaw on behalf of the court. So we'll spend a little time with some detail on each of the orders. General Order 23-2018 deals with payment of installment filing fees. The minimum installments per chapter did not change with the entry of this order. Chapter 7 installment payment, minimum installment is $75, as is the case in Chapter 12 and Chapter 13. The Chapter 11 minimum installment payment remains $339. What did change of significance is that the deadline for receipt of the initial installment payment increased from 7 days to 10 days. The second installment is still due 30 days from petition date, and the remaining payment, final payment, is due 60 days from the petition date, absent any other order of the court. But the initial 7-day deadline is now a 10-day deadline. This order is effective as to all notices and orders described in the general order in cases on or after December 1, 2018, and as to those cases, replaces General Order Number 16-2013. For purposes of this recording, there were no questions during the live session with regard to General Order 23-2018. I will now move to General Order 24-2018, Voluntary Notice Procedures in Chapters 7, 11, 12, and 13. This order is actually not a brand new procedure. It supplements rather than replaces the procedures for notice of hearings and opportunity to object found in bankruptcy rules and local rules. But the order does provide some important specific direction with regard to the notices and orders and how they are presented. So we will spend some time talking about this and answer any questions that may come up. So the most important thing, one of the most important things to notice is that while these procedures may be voluntary in nature, if an attorney chooses to use the notice procedures, there is a mandatory form of notice that is part of the order, that is Exhibit A. And this is the notice of pleading, deadline to object, and hearing. And this is a mandatory exhibit. So be sure to be very familiar with that. Unless otherwise directed by the court, the notice procedures may be used only for pleadings seeking relief in 16 specifically identified motions. And you will find that under paragraph A of the order, and they are listed out, number 1 through 16, and include, but not limited to, motions like motion to use, sell, or lease property, motion to extend time to object to the list of property a debtor claims is exempt, motion to extend time to file a motion to dismiss under 707B, motion to convert under 706B, motion for compensation pursuant to 11 U.S.C. 330 and 331, and so on. And there's, as I indicated, there are 16 specifically identified motions to which this order applies. It's also important to note that these procedures may not be used by a pro se litigant. And for attorneys using this procedure, you may not use the voluntary notice procedures if a request for one type of relief listed in the general order is combined with a request for relief in which a hearing is required. So, in other words, if one of the types of relief you are seeking for your client comes under number 1 through 16, but a combined request does not appear under 1 through 16, you may not use the voluntary notice procedures. All affected motions must be of the type listed in this order. A couple of other things to point out. Under paragraph E of the order, this refers to motions to abandon property in Chapter 7 cases. It specifically lists when the procedure can be used and what the objection deadlines are, so I would refer you to paragraph E for those specifics. Paragraph F deals with Chapter 13 and the Chapter 13 trustees requirements. So let me point out a couple things here. Is the Chapter 13 trustees are not required to file an objection to any motion by the objection deadline, any motion listed in this voluntary notice procedure. And also, and importantly, no order will be entered in a Chapter 13 case without a hearing. using these procedures unless, and I'm going to quote from the order, the Chapter 13 trustee either affirmatively consents to the order or has no opposition to the order as shown by an electronic or other signature on the order, including by express permission, unquote. So please make reference to this in paragraph F of the order. And just by way of practice, back in the day before e-orders and CMECF being required, it was the general practice that judges would not enter a Chapter 13 related order unless the Chapter 13 trustee or one of his or her staff attorneys had signed off on the order. And I think the process has drifted away from that a little bit. But in terms of these notice procedures, that is a requirement that the trustee either affirmatively consent or indicate no opposition. So again, refer to paragraph F for particulars with regard to that. Also, be sure to submit your order as soon as possible. It will take a day or two for an order or more, depending on what day of the week it's submitted, for an order to be processed and actually appear on the docket. So paragraph G of the order spells out that a proposed order submitted pursuant to the notice procedures granting a motion, if it has not been entered at least 1 day prior to the hearing, counsel for the movant must attend the hearing. So it's on responsibility is on the movant to make sure that the order is submitted early enough in the process that it can be processed by the clerk's office staff, by chambers first, clerk's office staff, and docketed, and appear on that docket at least 1 day before, 1 business day before the hearing. Specifically stated in the order, and this is under paragraph G, it says do not call chambers to ask if you have to appear at a hearing. If you do not see the order entered and it was not entered at least 1 business day before the hearing noticed, then you have to be there. Paragraph H of the order talks about what is required in the proposed order, and it's what you might expect to give the court full notice of applicability of your motion notice and notice before submitting an order. The proposed order must state the notice of the opportunity to object and for hearing and how it was provided pursuant to the general order, and that no objections were filed before the objection deadline. And of course, in a Chapter 13, we already know it has to have certain either signatures or no opposition by the trustee or trustee's attorney. So paragraph H talks about the proposed orders. And just want to reiterate that this, and it's stated so in paragraph I of the order, that the procedures are voluntary. If you don't want to go through these procedures, you don't have to for any of the listed 16 matters. Just go through your normal process. But if you choose to voluntarily use the notice procedures, then you must use Exhibit A form of notice. So the process is voluntary, but if you choose to do it, the form of notice is mandatory. During the live presentation on November the 9th, there was a question about whether the enhanced voluntary notice procedures in General Order 24-2018 affect the current practice of compensation for Chapter 13 debtor attorneys that is set forth in General Order 22-2017, which was entered by the court last year in connection with the adoption of a Chapter 13 local plan form and the accompanying general orders. The answer is no. The current practice of obtaining the attorney's fees and costs pursuant to General Order 22-2017 are not affected by the enhanced voluntary notice procedures. So specifically, the current practice is the signature of the Chapter 13 trustee or staff attorney is not required on an order presented if an attorney follows the protocol set forth in last year's General Order 22-2017. And to reiterate, that practice is not affected by the enhanced voluntary notice procedures contained in General Order 24-2018. Period. Also want to remind practitioners that last year's general order with regard to attorneys' fees, expenses, and costs does contain a mandatory Exhibit A that's entitled Order Setting Objection Deadline on Application for Compensation, setting hearing if objections are filed, and granting application in the absence of filed objections.
So the third general order is General Order 25-2018, and this is electronic service of pleading. And this order applies to all pleadings and documents filed in any case or adversary proceeding on or after December the 1st. So just by way of a little history, because some of you are really young, the Northern District of Georgia was the pilot court for Chapter 13 CMECF back in 1997, 6 or 7? 97. And, of course, that was a whole new world then. And there were lots of questions back in that time about how you're going to serve, and you filed electronically, and you get these electronic notices of receipt of documents and things like that. So we have currently in the local rules, a kind of a cumbersome process about if you can file electronically, but then you actually have to send an email to somebody with the documents you filed electronically. And that was, grew up in that period of time when we weren't sure how things were going to work. So the intent of this general order is to really make electronic service, a notice of electronic filing service, what it was intended to be, which is if you're a registered user, if you're a registered CMECF user, and you file something, registered users in that case are going to get a notice of electronic filing, an NEF. That is your service. Now, there's exceptions, and we'll talk about that. But the intent is electronic service and notice should be what it is. You got notice. So that's where we're moving with this general order. And as I say, it applies to the main cases and it applies to the adversaries. Filing is deemed to be service on a registered user who has appeared in the case or the adversary. So that's kind of the key, which is how do you know what registered user has appeared in a case? So we're going to kind of walk through where you find it. Well, I have screenshots coming, but this is where you would go. You would go into CMECF, you go in utilities, mailings, mailing info for a case, enter the case number or adversary, and it's going to show you. And I'm going to show you this right now. But while we're here, let me just make one caveat to this. The Office of the United States Trustee is added as a party in interest, is added as a party in Chapter 7 and Chapter 11. That does not mean that an attorney has filed an appearance in the case. They're a party in interest. They appear on the docket, and I'll show you, how that looks. But look, if you read the note on this slide, it says the provisions of this order does not apply if the generic United States trustee email address, which is shown right here, see what it looks like, USTP region 21.at.ecf. That's the generic email address where everything goes because they're a party in interest. And this will appear in the utilities, which I'll show you in a second. The Office of the United States Trustee is an entity and not a registered user as contemplated by this order. Now, that doesn't mean you can't ever serve the United States Trustee by electronic NEF service. We're going to talk about how that is, but I wanted to make sure you saw it and make sure in the PowerPoint that this is what the generic email address looks like. So here are the screenshots for what we just said. So you're in CMECF, across the top, you see utilities. Then you see mailing, it's highlighted in red. Then you see mailing info for a case. There's where you would add your case number or your AP. And there you're going to see who is getting electronic notice. Now, I picked this particular case because you see it has the Chapter 7 trustees there, Michael Barger. It has Office of the United States Trustee, that's their generic. So this, if that were the only one there for the U.S. trustee, that is not registered user service. But in this case, Janine Treese, an attorney in that office, filed a pleading. So she is added. Now they have registered user in the case, and they would be served by NEF service. Make sense? So that's where you go, and that's how you would know who you're serving electronically and who is not going to receive electronic notice that you would have to serve in other forms. Okay? So NEF service does not apply to debtors or non-registered users or registered users who have not appeared in that case or AP. So again, for example, well, let's use U.S. trustee as an example, but it could be any attorney who's a registered user. It could be any attorney at a creditor firm or debtor firm. Maybe a little different for that because they're filing the case. But until you may know that John Smith is a registered user at, I'm just going to say Colorama, because they always are in cases. But they have not appeared in this particular case, either by way of notice of appearance or by filing a pleading, then they are not a registered user in that case. They're a registered user in the world. They're not a registered user in that case. So NES service would not apply until they become, appear in that case. That distinction is clear, I hope. Okay. A named defendant in an AP or respondent in a contested matter must receive service under applicable bankruptcy rules. If the recipient cannot receive service via NES service, then again you have to serve according to applicable bankruptcy law. Debtor's attorney may be served via NES service when the debtor is a defendant in an AP or respondent in a contested matter. So you can't serve the debtor, but you can serve the attorney. They're a registered user in the case. They're subject to this service. And paragraph 5 of the order has recommended certificate of service language to use for both NES service, regular mail service, and electronic mail service. So the court took pains to sort of recommend to you the language that will be clear, so the court is clear on how you serve which parties. So I would urge you to review that language and use it. The general order also has paragraph number 4 that speaks to the use of electronic mail service as opposed to NES service. So in this, this paragraph is really, I think, intended to speak to a process that developed over time whereby parties could agree. I want to be careful how I say this. Parties could agree to send each other email service of documents rather than going through the formal requirements under the local rules. You would really only do it if you're talking about a situation where somebody hasn't entered an appearance yet in a case. So, for example, again, I'll use a creditor's lawyer. If you know that a particular creditor's attorney in a local firm is going to be involved in that case but they haven't yet entered an appearance, then you could send them a pleading or a document under just electronic mail service. It says such service is effective only if the court has ordered such service or the entity has title to the service of the pleading has agreed. So you can't just say that. You can't just decide on your own that that's what you're going to do. But if the parties have agreed, I'm Move-An's attorney, respondent's attorney, we've agreed to do this electronic service that's set out in paragraph 4 of the order, then that's acceptable service. Does that make sense? Sort of, I think, what's happening now in a lot of situations. And again, we talked about the order having specific language for this recommended language for the certificates of service. So I'm hopeful, I think the court is hopeful that this general order and the procedures that are outlined in the order will make all parties comfortable with the use of electronic service, and that the language provided specifically for the certificate of service will allow the court to be comfortable that parties have received service in a manner that is appropriate. So I would again encourage you to really follow the language provided by the court in this order. So questions about the electronic service of pleading? Awesome. Great. Make sure I don't have any other notes on this I have to tell you. Okay. So with that, we're going to move off of the 3 general orders and do a couple of other things. Any questions about that, any general order before we move on? Great. Okay. So there are some forms and rules changes December the 1st. Unlike years past, there aren't really substantive changes, but to a couple of things. There are a lot of changes, technical changes for the 8,000 rules for appeals and things like that. It is always your best information is going to come from reading the rules themselves. What I plan to highlight today is a change to Rule 3002.1B, and that involves the attorney fees, interest, and charges on mortgages. And so that rule has been changed in a couple of ways. B1 is amended to add, quote, if the claim arises from a home equity line of credit, this requirement may be modified by the court, unquote. So what this is basically saying, and it rose really out of some case law that where creditors' lawyers were asking the court to waive the requirements of 3002.1 in a HELOC situation because they could change every month. So every month you could be sending out payment change notices and fees and things like that that are occurring on a monthly basis. So this rule was amended to have let the court have flexibility on how to develop alternate processes or local rules on how to address these kinds of changes. B2 is a new section, and that creates the ability to file a motion to determine those charges and those fees and things associated with those changes. So the new language in B2 is a party in interest who objects to the payment change may file a motion to determine whether the change is required to maintain payments in accordance with 1322B5 of the code. If no motion is filed by the day before the new amount is due, the change goes into effect unless the court orders otherwise. So the intent of that is you can seek, there's no specific time limit on filing this other than if you don't file it before the change happens, it happens. But it could be filed at any point in time a year later, let's say. You could file this motion. If the outcome of that motion is the change shouldn't have happened, the payment change shouldn't have happened, that the mortgage company may be on the hook to repay things that were paid. If the outcome is the change wasn't allowed to take place, but the court determines what it should have, then the borrower may be on the hook. So timing, while there's no specific time that it bars it from being heard after the change takes place, it could affect whether payment money has to go back and forth, between the parties. But there is a mechanism to have a hearing, a determination on whether this should have happened in the first place. We, the court here, we're going to have a new event code in CMECF that will be live on December the 1st called Motion to Determine Validity of Payment Change. So that will be available. On December the 1st when this change takes effect. For our purposes, we're going to modify that slightly and have a prompt to that motion that says, is this loan a HELOC? And that way, if at some point in time we need to make a determination on how many of these are being used for HELOCs or for non-HELOC loans, then we could run reports to say, 80% of these or 10% of these are HELOCs. That information is only as good as somebody who's actually answering the prompt. We add a lot of prompts to things to try to make it easier for the filer. Some are mandatory prompts and some are informational, and sometimes people just blow by and don't respond. So this won't be scientific, but it will be helpful if the situation arises where the court or another entity wants to know how many of these new motions, are related to HELOCs. Other form changes. Minor change to the Chapter 13 discharge orders. The current language says, quote, debts for most fines, penalties, forfeitures, or criminal restitution obligations. And the new language is debts for restitution or criminal fines included in a sentence on debtor's criminal conviction. So that new language will appear in discharge orders come December the 1st in Chapter 13 discharge orders. And one of the many tweaks or changes to the 8,000 Bankruptcy Rules about appeals is there will be a new CMECF event live December the 1st for a supplemental statement regarding certification of direct appeal. We don't have that often, but if you are doing a direct appeal, this event will be available come December the 1st. So any questions about those particular highlighted rules changes? Okay. Wanted to tell you about a change that we're going to make, again, effective December 1st on the deficiency notices for new case filing. Presently, on a new case, when we're setting it up in CMECF and quality controlling what has been filed, the court generates a new case deficiency that goes out to the debtor's attorney, and it's specific as to what's missing and the date by which it must be filed. Come December 1st, instead of that being a notice from the clerk, that will actually be an order setting deadlines for debtor to correct filing deficiencies. The meat of the document is basically the same in terms of what's set out. We give you the date for each document and exactly what it is, so it's informative. And of course, for pro se debtors who come into the court to file, they get that information at the time they file, and then they get it also by mail, so they know about it the day of. But now it will actually be an order. That order will be served on debtor's attorney, if any, and the trustee. And if by the deadline set forth without further order from the court, the case may be dismissed without further notice or hearing. Basically the process we have now, but it's going to be in terms of an order rather than a notice issued by the clerk. So that will start happening on December the 1st. Any questions about that? Okay. One of the things to mention is regarding bankruptcy currents, bankruptcy local rule 9010-4 appearances. And I want to, I want to specifically reference the current local rule, starting with, I guess it's line 5 or 6, where it says an attorney who files a petition initiating a case on behalf of a debtor. And I'll go on to read where it says, or who appears for a debtor in a case other than special counsel for a limited purpose, shall represent the debtor in all matters in the case, including contested matters and adversary proceedings, until the bankruptcy court permits the attorney to withdraw in accordance with Bankruptcy Local Rule 9010-5. And I highlight that because for really as many years as we could go back and my folks we could talk about, the clerk's office does not automatically add debtor's counsel to an adversary, debtor's counsel from the main case to an AP if the debtor is a defendant. I don't know why that wasn't done all these years. It's been the local rule for as long as any of us can remember. But come December 1st, that will change. The debtor's attorney in the main case, if there is a debtor's attorney in the main case, will be added as the defendant's attorney and the AP, because as the current local rule states, basically you're into the case until you're allowed to leave the case. Yes. I'm looking to see if people. The question was, for those on the phone, that will that automatically be the attorney in CMBCF, or will you have to add that attorney when you're? Yeah, the clerk's office will add the attorney. And this, what will not change also, what happens now is that debtor's attorney in the main case, they already get NEF notice when an AP is filed. So it's not like they weren't aware of an adversary being filed. They get that through an NEF. But what wasn't happening through no fault of theirs is that they weren't showing up as the attorney for the debtor, a defendant in the AP. That will start happening as of December the 1st. No. If a debtor files a pro se, the answer to your question is no. And hold on one second. Sorry, no, because I didn't repeat your question for the folks on the phone. The question was, will this also happen if the debtor is the one who files the AP? Will the attorney be added? And that answer is no. And this is only if the debtor is the defendant. So if the debtor pro se files an adversary, they're pro se. If they are the defendant in an adversary, they are represented by their counsel who is appearing in the case until and unless the court allows that attorney to withdraw. Got it? Make sense? Right. think that's where the distinction we're making is that your client as a defendant, I mean, your client is based on the receiving end as a defendant. So yes, you're representing that party. If they choose to on their own file something, an adversary, without your knowledge, consent, or help, then they're on their own as pro se, subject to other order from the court. Well, yeah, I think that's the interpretation of it. I don't do interpretation. I didn't do that interpretation. Mm-hmm. Okay. Any other questions on that? Yeah. Okay, I got it. Okay, so one of the questions going back to the new order on notice of deficiencies is, will the court dismiss the cases if all the pleadings aren't filed or some of the schedules aren't filed? We do that now. I mean, that's not a change either. Based on the provisions of the notice that we use now, some cases are dismissed, but not all cases. It's a may. The court may dismiss the case. So I won't stand here and say that in every single case, if the only missing document is the Chapter 13 plan, that there's going to be a dismissal. There won't. I'll just tell you there won't. But it's a may. Okay. Right. So just a couple of general CMECF comments. This has gotten a whole lot better, but I just wanted to remind everyone that in using the new Chapter 13 plan form, it's a, what's the phrase? Dynamic, thank you. It's a dynamic document because you can keep adding to it and the boxes will expand. I know you love it too. So it's a dynamic document. So before you file it, you have to flatten it. If you don't flatten it before it's filed, and flattening it is to save to PDF or print to PDF, then when it gets uploaded to the court, it's not an entire document. It's one page. That's how we know you didn't flatten it. And so we have been doing outreach to attorneys saying, you have to file it again, and you have to serve it, by the way. If you're filing it in the proper form, contemporaneous with the filing, which is interpreted by the court day of the filing of the petition, we're serving that. But if you don't file it properly and you're contacted and you have to flatten and refile, then that service is on you. So just please be conscious that it has gotten a lot better, but not 100%. And so while we're speaking about flattening documents, we just encourage you to, before any documents are filed with the court, whether it's a pleading, a notice, anything in order, that you flatten that document. And to do that, you print to PDF. That locks it down. And again, reaching back to the beginning of CMECF, that was driven home to us, I remember, when we're sitting there in all those meetings, is print it to PDF before you upload it. Print it to PDF. That locks the document down. What's happening, and I understand that people are creating templates in different formats, and they're not flattening those things. So sometimes when things come to the court, you may think you've redacted it, but sometimes with the viewing of it, if you haven't flattened it and locked it down, those things are available for view. So that's the key to this, is to publish, print it to PDF, or save it to PDF from Word. Mm-hmm. And if you're using an Acrobat, then it's just print to PDF. That's the key. That protects your document and your client and you, that you're actually filing what you intend to file, that it's not subject to change or view, different view. We have made some updates to the CMECF administrative procedures that will be posted also on December 1st to address some of the other changes that are going on. So you can always find those on our website under the CMECF tab. Go down to CMECF administrative procedures. There's a lot of good information. We simplified that a lot a couple of years ago. Excuse me. So it's a 8 or 10 page document that is chock full of helpful information. So we'll hope you use that. And also the little green eye. And I know every year I talk about the little green eye. And I'm going to go back to the screenshot. I think see if you see up here under procedures, the top bar, the little green eye, hence the name. Anytime you're in a case and you you're saying, for example, I need to file a motion to voluntarily dismiss one debtor or the joint debtor. If you click on that, it's an easy, excellent search feature, and it will take you step by step on how to file, what to file. We had a similar little green eye for internal purposes, and then we created one for the external filer. It's excellent. So if you don't use it or your staff doesn't use it or know about it, please click on that. It relates back to local rules, federal rules, why we do it, how it looks, the order in which you file something, super helpful. So I just encourage you to use it. We love the little green eye. We've been talking, I think, for the last 4 years about the local rules and the review of the local rules. It started with the first mention bar, and it has started and stopped many times for various reasons, a lot of which because of all the December 1 changes that have happened over the last couple of years, and then the Chapter 13 plan form. The excellent news is the review of the local rules is complete, and contact has been made with the district court about next steps to get those in the pipeline for approval by the district and circuit court. And the process, can take maybe a year or more, maybe not, but we send them up to the district court. They review them. They give us the go-ahead to publish. We then publish, have a comment period. We respond to any comments and questions from the bar. We have to go back to district court and say, here are the questions we got. Here's our response to the questions. If they're okay with it, bless it. We get the okay. We send it up to the circuit. Circuit counsel approves them. They become our new local rules. So this has been a journey of endurance and love. But maybe by the next time we meet, be it in person or on WebEx, I can tell you that the new local rules will be effective on a certain date. So it's a lot of work, and I commend, I'm not just saying this because some of them are here, but I commend our judges because the bench and bar committee did a ton of work on these and several groups within the bench and bar. And then when new members came on, the new members took a fresh look. So lots of good input and has gone into this. And then the judges got them. And they just spent a lot of time. Really thoughtful changes, simplifications. I think they'll be a really good tool for the court for a long time because we don't ever want to do this again. Well, I don't. Next book. I want to mention just a couple of things. Locked-out report. I think you know that we have. You get locked out. Maybe you don't because you're all here. But attorneys who don't pay fees in a timely manner through CMECS get locked out, and that means you can't file anything. And so, it happens sometimes. You close out and you forget to check out and pay. But sometimes people stay on that locked-out report for a really long time, and we get it every day. And so we're having to make phone calls to people saying, what's going on? So I just say, if you get a notification from the bankruptcy court that you are locked out of CMECS, please take action immediately. Because you may find a situation, and we've had it, where an attorney is locked out, but they didn't do something that day, and they didn't know they were locked out. And then it becomes our problem and our emergency for that. So I just say, if you get a notification from the court about this, you need to take immediate action. And then one other thing, and I'm told this isn't happening that much anymore. This is from the 12-1 changes last year with the new plan. That sometimes, as you might imagine, sometimes attorneys take the wrong docket event for things. There's a lot of them, and it happens. But for a while, this was a big problem. I think it's a lesser problem now. But instead of picking the notice of hearing on confirmation of modified plan and deadline for objections, which goes with the new plan and the 12-1 forward, December 1, 2017 forward cases, attorneys are picking notice of extension of confirmation, which was the old notice, but we left it in as an event because there's lots of cases still pending that were filed before December 1 and not subject to all the new rules. So just be really careful about which one of these notices regarding the confirmation hearing we're selecting, that it's the right one for the right case, depending on when you file it. And then my last thing, unless there are questions, when we first sent out the general orders and the notice about the meeting, we said you can submit questions in advance. And the question, we got one question, and it was regarding what we've talked about before, which is the service on the United States trustee. I went ahead and left the slide because I think think it helps to reiterate it, is that the question was simply, does General Order 25-2018, Service of Pleadings, apply to the U.S. trustee? And here's the answer. We've talked about it already. It depends on whether a registered user within the Office of the United States Trustee has entered an appearance or filed a pleading versus if just the Office of the U.S. Trustee as an interested party is listed. And we talked about verifying that. But I did want to make sure we had it as a slide because it was a submitted question. And that is the only question I got in advance. So, are there any questions or things to talk about that I have? So, unless there's anything else, we will conclude today, and I thank you for coming.